Before we get to this week's episode, we do have a disclaimer. Our discussion includes general comments and does not constitute legal advice. The legal position will depend on the facts and the circumstances of a specific case and the applicable laws of the relevant jurisdiction. If you have any queries in relation to your own circumstances, you should seek legal advice from a qualified lawyer or attorney. Enjoy the show.
Y'all ready to be history? Get started.
Welcome.
Hi.
Hello, everyone.
To the Pro Audio Suite, thanks to Rode Microphones.
These guys are professional. They're motivated.
Introducing Robert Marshall from Source Elements and Someone Audio Post, Chicago. Darren Robbo Robertson from Voodoo Radio Imaging, Sydney. Tech to the VO Stars, George the Tech Whittam from LA. And me, Andrew Peters, voiceover talent and home studio guy.
Line up, ladies!
Here we go.
Welcome to another Pro Audio Suite. This one, we're taking a legal journey into the world of AI. There's been lots of discussion about AI, but no one's really looked at the legalities of who owns your voice. So we've managed to secure our legal person, Stuart Green from Davies Collison Cave in Sydney. And we're going to talk about who does actually own your voice and can you own your voice and trademark it. Welcome, Stuart.
Thank you, Andrew. Pleasure to be here.
We should probably be clear too that you're actually a trademark lawyer, correct?
Absolutely. So, look, I'm a branding and trademark specialist, which in a nutshell means that I help people protect, enforce and defend, in inverted commas, the signs that sort of differentiate and distinguish their goods and services from other traders.
You know, when you mentioned taking a journey, I was about to play the Twilight Zone, and I was like, nah, I might get sued.
Yeah, who owns that?
Yeah, really. Somebody with big pockets bigger than mine.
Yeah, indeed. Now, the discussion we've talked about this many times before, and in fact, Robbo and I were having a chat just yesterday about this, and like if I capture my voice on the DAW and look at the waveform, is it going to show some kind of fingerprint that's going to be different to anybody else? So that's getting into that technical side. Do you know the answer to that, George?
Oh, boy. No, but I know it's going to be a change. That's a moving target. I think that because we're going to figure that out.
Yeah. Because what I'm trying to do is trying to sort of compare a visual image to an audio image, because this will be correct, Stuart, I hope, that if someone uses your visual image, then you actually own that and they have to pay. Is that correct?
So in terms of speaking about generalities, it's extraordinarily difficult to do that in terms of, I guess, any area of law, but especially when we're talking about different jurisdictions.
There's going to be a lot of simplifying today. Is that what you're saying, Stuart?
I think the general lawyers, indeed, the general lawyer's answer you're going to get to most things is that it depends. It depends. So it's going to depend on a number of things. Look, there are various buckets of or areas where the existing law can assist in protecting sort of different rights, but in terms of what we're talking about, a voice right, it's really going to be a question of looking at the existing sort of matrix of laws that exist in a particular jurisdiction, and then sort of working out, whether we can sort of fit a round peg into a square hole type situation, and working out what from each area might be used to protect. Because we have, what you're talking about there, Andrew, is really around copyright. And copyright's obviously, the term that it's used to describe the rights that creators have over their literary or artistic works. And that the copyright protects the expression of the idea, but then copyright protection obviously gives the copyright holder the exclusive right to use that work and copy the work and modify it and distribute it and perform it and display it. But it's really just going to be a question of, is voice considered something that's copyrightable? And I think, as part of a broader work, it might be, but in and of itself, I have a big question mark over that. And from what I understand to date, that's not something that's really going to be helpful, I guess, in protecting that voice right.
A quick question in the context of the fact that, everybody knows this is in context of Australia. So Stuart's not going to know the nuances between the U.S. and Australian law, but Do you have some basis of knowledge of U.S. law enough to say, well, this would probably be quite different in the U.S. because the U.S. bases their law on a different set of precedents, or we're based on the U.S. Constitution, blah blah blah. How does that rub you?
Yeah, no, George, you're absolutely right. Look, the answer to to question is a voice protectable, or is the sound protectable, is always going to be different depending on the jurisdiction.
Right.
I'm not a US qualified lawyer, and I don't profess to be. And as I said, my specialty is more the trademark side, and perhaps I'll perhaps speak to sort of how trademarks can protect sounds in a minute. But in terms of the US aspects, I mean, the US is different. The US has different rights. I guess it's probably best to sort of step back, go back to first principles and sort of these sorts of things, because when we're talking about the suite of rights we're talking about intellectual property or IP, and that's sort of the broad suite of rights that's designed to protect intellectual and creative endeavors and sort of intangible creations of the mind. And your listeners will no doubt, and you guys would have heard of sort of trademarks, copyright, designs, patents, trade secrets, confidential information, that sort of get up.
So is IP an umbrella over all of that?
Indeed. So that's exactly right. So in that context, just to answer your actual question, though, in terms of sort of the US will have different remedies and different, I guess, causes of action that someone who wanted to protect their voice and want to enforce their rights in what they believe to be something they own would be able to rely on. I guess in Australia, we'd be looking at sort of the misleading, deceptive conduct provisions of the Australian consumer law and the broader IP suite of rights that are available. I think the US equivalent would be something along antitrust. But then equally, there's been a bit of case law in the US that I'm aware of in relation to sort of publicity rights and sort of the common law rights that a person who does have a reputation in their voice or in their works would be able to rely on. And I guess the two cases that immediately come to mind would be Bette Midler, who sort of took the Ford Motor Company to task a number of years ago when her voice was imitated in an advert by Ford. And the court in that, and again, this is just of what I've read, so again, not a US lawyer, but just what I understand. The court in that decision sort of held that the voice is not copyrightable, but Bette Midler was afforded common law rights for the appropriation of her identity. So, a voice is distinctive and personal, and, it is one of the most palpable ways identity is manifested. So the voice in abstract is not going to be protectable, but underlying work, including a recording of the voice or the work, could be protectable. And the other one, so that comes to mind, is Tom Waits, the famous singer-songwriter who's got an extraordinarily distinctive voice. And he sort of took the Frito-Lay people to task, where his voice was imitated in a radio commercial for Doritos. That was sort of in your neck of the woods, George, under California law. There was an appropriation of publicity rights, and the use of someone who sounded like Tom Waits implied an endorsement under federal US law. And there's actually a really good New York Times article on that, which is sort of going back to 2006, where Tom Waits is speaking to that issue. I might send that to you guys so you can just have a
Well, when you type Tom Waits Doritos commercial into Google, hit number one is a YouTube video called Tom Waits Lawsuit.
There you go.
There you go. Wow. So if you want to learn about it, it's not hard to find information. So thanks for that context. I appreciate it.
But I guess that leads to the next point, which is who's actually going to take action and who has an ability to take action. And it's usually going to be a person who does have an existing reputation and has the funds, really, to actually litigate and take someone to task.
I think the funds is probably that's the key issue. I'm gathering that no one's going to be able to afford to take any of these people to court.
Well, yeah, I mean, it's obviously it comes down to a commercial decision. Tom Waits obviously has a significant reputation in his voice and the works that he produces, and therefore, it's a case of why allowing someone else to leverage, your IP effectively. and your reputation in support of their own commercial gain. I guess, if we're not talking about parody or, something, that's not being used in a commercial sense. We're really talking about
voice matching. We call it voice matching here.
Okay.
Yeah.
Which people do routinely. They get paid well for it. It's a skill set, and it's not a parody. It's really meant to save the client money.
How would you prove all this in court, regardless of whether we're talking trademark or we're talking copyright, with an audio logo like the famous, dung 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 for Pentium or whoever that is? Is it Pentium or Dell? Intel. Sorry,
Yeah, that's right.
With the famous dung 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 for Intel, that's a set of notes on a keyboard that you can prove, that's the order and that those notes get played in, and that's our. How do you do that with a voice? Because I can be in a recording session and I can ask the voiceover artist to go up in pitch or down in pitch or change their voice to get the recording that I want, even if I'm not trying to match someone famous. I'm just trying to get the sound I want. How do I know that, or how would you prove that that's infringing on someone else's voice?
In the case of trademarks, and that's what I can probably speak to, again, I think it's probably best to sort of go back to first principles on this and then come a long way of getting around to answer your question.
Yeah, no, that's all right.
Robbo. But so sort of taking back to first principles on trademarks. So the trademark, what we're talking about when we're talking about a trademark, we're talking about a sign, which could be, the word, the name, the signature, the sound, the letter, the smell, the logo, whatever it is, that's used in the course of trade to distinguish one trader's goods from those of another, goods or services. So in order to secure registration, trademark needs to be different from prior marks. It needs to be distinctive in relation to the goods or services for which protection is sought. And so in terms of distinctiveness, that means that what you're trying to get a monopoly in relation to is something that other traders do not need to use or are unlikely to require in the ordinary course of their businesses. So sound trademarks are considered non-traditional trademarks. They're fairly new and recent invention, looking at the overall arc of sort of the formation of and evolution of trademarks. But the key principles of securing a sound trademark are that they need to meet not only the standard criteria of being different and distinctive, but they also need to sort of be represented graphically and include a clear and concise description of the trademark. So when you then secure or apply for it, when you apply for a sound trademark, what you are needing to do is you need to provide a sound recording, and then typically you'd also need to provide a description of what it is that you are protecting. And so sort of the Intel Corporation sound trademark that you mentioned there, Robbo, is a good example of that, it's a 5-tone audio progression of the notes D flat, D flat, G flat, D flat, and A flat. And basically a trademark is going to be examined by the relevant jurisdiction, the relevant examining authorities in the particular jurisdiction. In Australia, it's IP Australia. In the US, it's the United States Patent and Trademark Office. And they're going to go through a number of criteria to determine whether, as we sort of said, the trademark is different and distinctive and actually meets the registration criteria. Once you then have that trademark registration, you can use that both as a sword and a shield. So, Intel has the ability to then, if they come across someone who is using that particular sound trademark in relation to, the computer chips and processors that they produce, they would be able to then, initiate trademark infringement proceedings against that particular entity or person who is infringing their trademark or allegedly infringing their trademark. So in terms of, the evidence that you'd need to sort of collect and collate, it's, you need to, ensure that you actually have the right. So from a trademark perspective, that's, registering the right. From a copyright perspective, in the US, you can register copyright. In Australia, it's an automatic right. So, it's about then keeping records about when you sort of came up with the expression of work, and then being able to sort of, paint the narrative and the picture as to, why it is that a third party is infringing your rights in that particular work or trademark or whatever IP right it might be. There's not going to be any one... This is, again, it's going to be the answer is that it depends. There's never going to be one sort of way of doing this for all cases. It's going to be a case of sort of evaluating the facts and circumstances of the case and and working out, what do we actually need to be able to prove infringement. And but as with most cases, it's about understanding your rights, securing your rights, and then collecting the evidence to demonstrate that someone has either leveraged your it's basically reproduced your rights without authorization.
Here's an interesting angle. There have been, over the last 10 to 15 years, online casting sites. Basically, voiceover people audition for jobs and they send in their MP3s to these sites. Now, those sites hold those auditions and they have thousands upon thousands upon thousands of hours worth of voice. If one of those sites decided to set up an AI company and use their database or their store of voices, what would be the proceedings if you've given them an MP3 of your voice on many occasions? What right do you have to stop them from using your voice as an AI?
So this is really, really important issue, and kudos to you guys for actually having this discussion, because part of answering this question is really just about arming people with the knowledge to know that what the ramifications are of providing your IP, your recording to casting websites or other businesses. I guess the thing to think about, again, going back to first principles, is it's really important to think about contractual rights. So what are the terms and conditions that you're signing up to with this particular website? Is it clear from the website how your voice is going to be used? If not, big question mark, is it a good idea for you to avail yourself of that sort of avenue to secure work? Most of these things are going to come down to contractual terms and rights. And so I think it's fairly important to think about, what's the gig? How is the recording going to be used? Making clear that the work that you do is not to be used for anything beyond the particular gig at hand. So is it likely that you're going to receive credit for that work? Is there a time limit on their use of the recording? Are they going to destroy the recording after a particular time? Are there royalties applicable? Those are all sorts of things that you probably need to look at. But I think by having this discussion, you're effectively educating the talent out there so they sort of understand that there are traps and pitfalls. As we sort of said from the outset, the legal remedies that might be available are going to depend on the particular circumstances of each case. And that's going to sort of be determined by the location, the available laws, the activism of the industry representatives, I guess, and their member organizations, perhaps unions, the engagement of the media, and government receptiveness to change. Because if we say that, things aren't going to change unless sort of people make law and have the funds and, wherewithal to take someone to task and litigate, really the only other way that action will come is through legislative change. And so legislative change will obviously is, whether it's Congress or Parliament, it's government-made law. Sometimes governments will do the right thing and see a problem and address it, but vast majority of the time, it's about lobbying and getting the issue in front of the relevant lawmakers to ensure that concerns are heeded.
Mm. If there was legislation put forward to government or Congress and it was approved, could they actually approve it historically?
I'm probably not going to answer that one.
There's your answer.
That's a so retrospective legislation is possible, and it's going to depend on where it happens. It's a dangerous one. It is possible to make retrospective legislation, but I can't speak authoritatively on that, I'm afraid.
Well, the issue I have is that no one was discussing AI. In fact, it's only a recent thing. But the storage of all these voice samples has been going on for, like I said, 10, 15 years, maybe even longer. So people actually were more concerned about someone stealing their audition and using it as a final. No one ever thought about this point where that information you've given them can be used in AI. we weren't signing contracts saying you cannot use my voice in AI because there wasn't AI.
It's a case of the law going to be having to catch up to, the commercial reality, unfortunately. I don't know which way to go on this one, guys, because it could go either way. I mean, there is a possibility that, governments might come in with legislation to retrospectively say, these things now apply, but I just don't know enough about,
So let's come at this from another angle then.
Yep.
If I may, and let's use Australian as the example, because you can answer to Australian. If I'm an Australian voiceover artist, I'm listening to this episode and I'm now quietly crapping myself for the last 10 years, I've been loading up one of these voiceover websites with hours and hours of my voice. And I think, shit, I'm not protected. Is there anything I can do right now to say exactly what AP's saying? AI was never in the mix. It now is. Can I go to a lawyer and go, I want to protect myself, or am I basically screwed?
I would never say you're screwed. I think it's about taking a step back and going, okay, so what were the terms and conditions with this particular website that I've been uploading my work to? If it is a sort of an audition and it's sort of a speech or a performance or something, there is likely to be an ability to rely on copyright to sort of a moral right or an attribution right, and that would probably need to be explored. First of all, check out what were you signing up to. So it's important to understand sort of what did I sign up to. So what did I do? What did I upload? If you still have records of it, sort of to do a bit of a health check and an audit about where I stand. And then, it is, if you do speak to a lawyer, they will go through, the particular circumstances of the case. When did it happen? What was uploaded? If we can categorize the files that were uploaded as a work, then there may be copyright protection, as I sort of said, and there may be sort of an ability to sort of pursue a query around moral rights. So moral rights, sort of just to take a step back as well, moral rights is sort of a subset in copyright, but they protect the relationship between the creator of the work and their work, even if the creator no longer owns the work or the copyright in the work. So that's sort of where I'm thinking there might be an option, because, again, it's a question of, well, moral rights only rarely concern the right to be properly attributed or credited, and the other thing was to protect the work from derogatory treatment. I guess theoretically, and again, depend on the circumstances of each case, if someone uploaded a performance and it was used by a company which perhaps bring the performance or the performer into disrepute, then there'd be an argument there. Or if you definitely know it was your performance, then you'd have a right to have that attributed to you or credited to you. That's sort of where I'm thinking you'd go.
Sure. So that's the performance. Does that include the sound of my voice though?
No. So look, I've been thinking about this, and I just can't see how, absent a voice image right or a reputation, you can protect the voice itself as things stand right now. So the best way for people to protect themselves is going to be getting on the front foot contractually, and ensuring that you sort of have eyes open, understanding of what you're getting into when you do sign up for a gig, and sort of just limiting the manner in which your voice can then be used, and limiting it to that particular performance or that gig.
Wow. Okay, that opens a massive can of worms for the industry, doesn't it?
It does. And the other thing is, if laws are different in each jurisdiction, then someone set up camp doing an AI in a place that doesn't have any legal ramifications for basically voice farming. Where do we stand with that? Can we take legal action against them from here?
It's going to, again, be a question of standing. That's where the lawyer will come into it and do the research and the DD and due diligence around sort of, if they are in some sort of jurisdiction that they're untouchable, which, many companies might think of doing, there may be other ways of getting them. There's this is perhaps where the United States might come into things with their sort of doctrine of extraterritoriality. US law applies anywhere that a US citizen is sort of affected. So the US might need to be the one to lead on that one, I think.
Would it be like, say, for instance, there are, say, 10,000 voice people who have given samples of their voice to we'll just use website because it's just easier, to a website who now turn themselves into an AI company, would you do this en masse using all the thousands of people to prosecute?
So you're saying in terms of a sort of a class action type situation?
Yeah, class action, yeah.
Again, not a class action lawyer, and I wouldn't be sure on that one, to be honest. I think you need to speak to a class action lawyer on that one. Sorry, I don't.
No, that's fine.
There's obviously limited things I can speak about, and I'm not sure that misleading your listeners is going to be the best idea. So
we do it every week.
That's right. Exactly.
That's our theme.
Sorry, George, did you have something?
I was just trying to slip in a dumb joke to add on to the rest.
Go for it.
Slip it in now.
I'm listening very intently because I realize how challenging it is as an attorney. Attorneys know what they know, and they've studied what they studied, right? And there's no way one attorney can know the breadth of the cases that are so related to this topic. There's so many. It would take a room of attorneys to
Indeed.
cover every single aspect of what we're talking about here. So, everybody give this guy a break, all right? When you're listening and he says, I don't know, or I can't speak on that, that's the long and the short of it.
So many rabbit holes to go down, isn't there? So let me ask you this then. Again, speaking in terms of Australian law, so maybe it makes it a bit easier for you to give me an answer. But would you suggest then that if people continue to use these sites from here on in, that when they do their audition, do they need to do some sort of legal disclaimer at the end of their audition that says the recording of this voice and anything associated with it is claimed by me, blah, blah, blah? Is that going to help?
Well, look, that's not the worst idea. And the fact is that if you're doing that, you're sort of putting the entity that you're sort of sending your work to on notice. So I can think of worse things to do. That might not be the worst idea at all. But again, it's about looking at, I assume, and I don't know, but you guys would have to tell me that such websites would have sort of clear terms and conditions around how an audition is going to be used.
AP, I don't know. Over to you on that.
I don't know.
Yeah.
I don't know. I would have to have a look and to see what their T's and C's are on the actual site. But
So I think,
I would get my feeling is that with this there will be nothing talking about AI and probably the use of any of the voices for AI. That's kind of what I'm thinking. But the other, if say for instance you could use a waveform that actually is like a fingerprint, so every voice has its own waveform. If we could establish that was real, which we don't know, someone technical out there probably does. But if there was a fingerprint of your voice that makes it indistinguishable, like it is, distinguishable from anybody else. If that was the case, could you use that as a trademark?
So not as a trademark. Okay, so going back to sort of, again, first principles. So when we were talking about trademarks, remember the trademark is there designed to be used as a badge of origin for particular goods or services. So it's in the course of trade. So it's acting as that sort of market identifier. So technically, anyone's voice could be used. And let me think of a couple of examples here, perhaps for US and Australian context. So I guess from a US context, you could think about, I can't think of the gentleman's first name, but Buffer, sort of Let's Get Ready to Rumble, who sort of does the UFC.
Michael Buffer, I believe.
Michael Buffer? Okay. He's got a fairly distinctive voice. He's got a fairly distinctive tagline. Similarly, you could think of, Australian tennis player Leighton Hewitt, who, when he was playing competitively, always used to urge himself on by saying, "Come on." If those guys wanted to use, providing they haven't licensed their ability to use that to someone else, if they were to want to use that as a badge of origin to sell goods or services, there probably is an ability for them to do that. But sort of as we said in relation to the trademarks, sound trademarks, what you're doing is you're then applying for that particular expression and that particular recording, and you're getting a monopoly in relation to specific goods or services in relation to that. So, you're not protecting the voice per se. You're limiting the protection to the recorded phrase. So, AP, to your point, the WAV file, is able to be protected as a trademark, but it's only for that particular expression, for that recorded phrase. It's not going to be for the voice in general. Take a step back and think of all the different sort of trademarks that have been protected. There is, for example, a song or a tune can be protected as a trademark. So Bega Cheese, for instance, has the Happy Little Vegemites tune. There's Metro Goldwyn Mayer Studios Inc.'s, they've got that Lion's Roar, which is extraordinarily distinctive in relation to their movies. And those are probably good examples of, how a sound trademark works, in that it is sort of acting as a badge of origin for particular goods or services. There've been times where other companies have tried to, secure the protection of sounds and haven't been as successful. And I guess the main one that comes to mind is Harley Davidson with the sort of the motorcycle, the roar of the engine. I'm just going to find it for you just so I can give you exactly what it sounded like. 1 second.
While he's doing that, I'll tell you that Michael Buffer, as of 2018, has made over $400 million from his signature phrase.
Wow.
Let's get ready to rumble.
Holy crap.
God, you're kidding me.
So this is the thing. It's not. Sorry. It's just. I'll come back to Harley Davidson, but this is the thing. It's a question of, if you have a phrase like that, you can protect the words, not as well as
not his voice saying those words.
Yeah.
It's those words said in that way, right? That's what's protected.
Exactly. He could protect both the words, the phrase, or he could protect him saying that. And then, for instance,
Gotcha, and then two different things.
Absolutely. And then, for instance, if I don't know if one exists, but for instance, if then someone wanted to come up with a UFC video game or something, and or a boxing video game, whatever it would be, and they wanted to use that, then he could obviously then license his voice to that particular computer games manufacturer or designer. I'm sure there are instances of celebrities and who are sort of licensing the voice to particular entities to make their product more attractive to consumers. In fact, I'm thinking out loud here, and I'm sure that, and I don't know if this ever happened, but didn't Bob Dylan was at one stage in discussions with it was a Garmin or one of the sort of
the navigation turn by turn.
Indeed.
Tom, those kind of guys.
Absolutely. So instead of having your sort of generic voice, you could be guided by Bob, or I don't know if it went anywhere, but I understand that there are people who there are celebrities who have endorsed those sorts of.
So we were talking like turn left in 200 meters, then continue straight like a rolling stone for 5 kilometers. Is that what we're saying?
Yeah.
Continue
They actually were
like
done.
a rolling stone.
Yeah, that's right.
Bob, I didn't quite get that. What did you say?
I might be sued.
Exactly.
No, I know
exactly.
Waze was doing that too with navigation. There was a tremendous, I think you could even have your own voice. But
Wow.
Dennis Hopper could give you directions on like a TomTom at one point.
Yeah.
Weird stuff like that.
Yeah. There's a bomb on a bus,
Dame
turn
Edna
left.
Everidge was one.
Right.
Dame Edna Everidge? Yeah, she'd be a good one too.
Yeah, Dame Edna did one, I think. I'm pretty sure.
Yeah.
So it's a question of those guys, and those artists, those celebrities, sort of licensing their voices for particular uses. And no doubt the legals around that would have been a contract, and a limited contract around the extent to which that could be used for, whether it was for particular products or a particular time limit, and obviously then the endorsements that would then flow from that.
Yeah.
Now, the exhaust note of the
Yes.
Harley Davidson.
So-
what happened with that one?
So Harley Davidson attempted to register the sound of the Harley Davidson motorcycle engine, and that was back in the 1990s. And the mark they applied for consisted of the sound of the exhaust of Harley Davidson motorcycles produced by a V-twin common crankpin motorcycle engine when in use. So they applied for it, but they were unsuccessful because a number of their competitors opposed the registration of that sound trademark on the basis that,
It's too
the
generic.
same. Yeah, indeed. That's exactly right. The crankpin V-twin engine was something that produces a particular sound, and other motorcycle manufacturers may want to use that particular engine, and then would be prevented from doing so because Harley had this, if they were granted the rights. So they ultimately didn't get anywhere, but interesting that they had to go.
It is and I guess, given the fact that, ask any Harley rider what they love most about their bike, it'll be the sound of it.
Here's a sound.
There it is.
You all know that sound, especially if you live near the beach, if you live near a mountain.
That's it.
If you live in Los Angeles.
Yeah.
You
live
hear
down
it
here
far too often.
Yeah. I'm just wondering if, the issue we're going to have with all of this is most bodies are reactive as opposed to forward thinking. And I think they'll be just chasing stuff which has already happened, unfortunately.
I think that's the reality with most things, unfortunately. Law is extraordinarily slow to move to accommodate new developments. And unless the Parliament takes proactive action, the Congress takes proactive action, it's really down to those judge-made common law decisions that will then sort of impact upon how, technological developments are treated. And it's about sort of, using the existing matrix of existing laws to sort of work out whether there is a remedy there. And there typically will be, because, if enough people agitate about something, typically, people start paying attention, unless there are, societal reasons not to accommodate something, or, particular interests being alienated or, overlooked, the law will eventually adapt, but it's, as I say, it's not sort of, tectonic shifts, not
yeah. Not tsunamis. Yeah.
Correct.
Yeah. So what would be the first port of call? Would you advise voice talent to talk to their agents, talk to their union, talk to each other?
It's certainly a live issue. So it's something that should be discussed, which you guys are doing. The more people discuss it, the more light will be shone on the issue. It won't hurt to engage in industry discussions around whether it is possible to, rather, not whether it's possible, but how the industry will need to adapt to meet the challenge that AI is going to present.
Just out of interest, is it just this industry that you've seen or you're aware of in general terms that AI affects, or are there other industries that can be greatly affected by AI in any shape or form?
I think AI is affecting every industry. It's affecting the legal industry.
Oh, really?
Absolutely. The automation of documents. There's some amazing work being done by IBM around sort of reading into decisions and predicting, how particular cases are going to be decided in particular jurisdictions based on prior law and particular judges involved. And it's all about entering data and analyzing that data. And, there is some amazing stuff going on. So AI is it's not going to, it is having a dramatic effect. And it's something that society and the laws and every industry is going to have to grapple with as we move forward.
Wow, it's crazy, isn't it? I actually think you sound fairly passionate about this, and maybe we should be getting the MEAA and SAG-AFTRA to get in touch with you and see what they can do to get the ball rolling.
I just don't think anyone's going to be reacting quickly enough.
No, I don't think so.
And because there's been no one's actually put anything in place. I mean, there's so many people who are freelance who are actually doing jobs in perpetuity. So it's like, well, and you're not saying you can use this as in this form in perpetuity. You're basically handing over everything in perpetuity.
I guess it would be interesting to see if it was implied by just, you provided a, sample or your audition tape for a particular purpose, and whether that would be read in by an adjudicatory authority as to, I did it for this purpose, therefore it was implied limited to that purpose. I don't know where that argument would work, but it's a challenging one, unfortunately, and definitely one that we're all going to need to grapple with, because it's sort of, as I was saying before, it's around the fact that available remedies are going to favour someone who already has that reputation and has the funds, because otherwise it really is around the unions and the representative bodies to speak to the minister, to seek an audience and raise the concerns and see if there's a favourable reception, and if not, work out what other strategies might be available to secure that voice right.
Wow. Well, it certainly sounds like at the moment that, as we said at the very beginning, if you got the money, you can cover your ass, but if you don't, you're pretty much stuck with what everyone wants to do with it at the moment. Unfortunately,
I think that applies for all areas of society. Really, those who have the ability to fund legal proceedings have an ability to be heard and have an ability to seek a remedy. Those who don't are left to the sort of the legislature and the Congress and the government-made laws to seek that protection. It's extraordinarily difficult, and it's unfortunately it's not clear-cut.
Well, looks like we've got some homework to do.
Yeah, and it's something I think we're going to stay on because it's a fascinating topic as far as I'm concerned. It's and it's something that needs to be addressed, as we've mentioned. Not everyone seems to be sitting on their hands, but I think the sooner the industry as a whole moves on this, the better it's going to be in everybody's interests.
It's definitely a topic of discussion that's being shared among the community here in the U.S. I mean, I just today saw a video passed to me from one of my clients. It was sort of a round table in similar terms. I don't believe there was any attorney involved, but it might have been more of a hand-wringing session.
Yeah.
But,
yes,
it's kind of like, what are we going to do? What's the technology capable of doing,
But I won't mention any names, but the interesting thing that came out of that for me, George, was that one that you sent us, was that there was still a certain amount of head in the sand naiveness about what they were talking about.
Right.
It was kind of interesting to me that they still didn't sort of accept the fact that, hey, this is here to stay and this is already happening.
Right.
And they actually don't need your permission to sample your voice.
Correct. Right.
So, the fact that they were still sort of talking about, down the track, maybe we need to look at this and this is still a way off and this is not true at all. It's here and it's now. That was the interesting thing out of that one that you sent us,
I don't know if that was said to be comforting to each other.
Maybe
it is. Could very well have been, yes. Yeah. Don't scare me.
Maybe in this day and age where Dr. Seuss books are taken off the shelves and all that sort of stuff, maybe that's what they were doing. Exactly.
Yeah, exactly.
Stuart, thank you so much. You've shed a great...
Thank you, Stuart.
Pleasure.
Massive spotlight on a shit situation, I think.
Yeah, no, good. I was just going to say that the other analogy that could be made with this is that it's a similar sort of situation to which the music industry faced with the sort of the advent of the MP3. It's got that sort of ability, the sort of the rise of AI in these terms, and for voice artists to be exploited in the way that you're sort of speaking about. I mean, it's game-changing stuff. And the analogy there is that again, it comes back down to the relevant stakeholders had to take action for there to be changes to the various, remedies available. But again, it was a case of looking at what the existing laws and how the existing matrix of laws could be applied to a really fast-moving situation. That's just how law works. It's one of those things. It's like, okay, there's something that's having a significant effect, and how do we address it? Will we look at what laws are available, and we can pick little bits and pieces from each, or what might be available, and can only put up the argument and then see if it is successful or not.
Well, I suppose, I mean, that's the thing. It kind of has to be reactive by its very nature, doesn't it? Because it's not until something arises that you can change laws. It's not like you can look ahead and go, well, this might happen.
Well, certainly from the judge-made and common law perspective, that's exactly right. The court can only rule on the cases that are put before it. Whereas Parliament, this is why Parliament and you get engagement and lobbying. It's up to the industry, it's up to the unions, up to, as you say, the agents and the talent themselves to advocate and to raise the issue and put it on the agenda and on the radar.
So in the meantime, stick a disclaimer on the end of your demos and your auditions then, by the sounds of it.
Not the worst idea.
Yeah, there you go. All right.
Well, that was fun. Is it over?
The Pro Audio Suite recorded using Rode NTG5s and Source Connect. Edited by Andrew Peters and mixed by Voodoo Radio Imaging.
With tech support from George the Tech Whittam.
Don't forget to subscribe to the show and join in the conversation on our Facebook group. To leave a comment, suggest a topic, or just say g'day, drop us a note at our website,
theproaudiosuite.com.